Moving on to sort of, we were talking before about the Supreme Court and the how this will challenge our rights. Um, a challenge to Florida's Don't Say Gay law was thrown out by a Trump-appointed judge.
Yeah. So we have a couple of stories involving judges who are pretty much holding to a conservative pattern. And the first one is don't say gay. Now, let me just put this out. The judge did not close this chapter. The judge basically said, look, you didn't provide enough evidence to say that this law is actually doing some form of harm. What you have brought to me is this is what the judge says. Um, with or without the law, school districts direct teachers as to what they may or may not teach. Plaintiffs do not allege otherwise. They do not assert, for example, that Florida's public school teachers may teach whatever lessons they wish. So, to the extent plaintiffs allege that some teachers or others wish to provide classroom instruction on sexual orientation or gender identity to students in kindergarten through grade 3, they would have to show, at minimum, that without the law, their individual school district would allow it. Yet plaintiffs offer no specific allegation that any teacher would be providing such classroom instruction absent HB 1577. So, basically this was a smokescreen thrown up to push those who had brought an argument against the Don't Say Gay bill, the Don't Say Gay law, to basically go back and reformulate their position.
Interesting, but it didn't seem like there was a lot of leeway in there for them to find, essentially what it sounded like to me when I read through it was that the judge is looking for evidence that the law itself has affected how students are taught and their rights.
Exactly. And that's the problem with that. It's asking for people to argue a negative, and then the court's going to come back and say you can't argue a negative. You have to provide proof that something happened. You can't provide proof that nothing happened.